Hello, and welcome to Three Questions with. Got my friend Darlene and Danielle with us. Good afternoon, Darlene. Welcome to the show.
Good afternoon, Kevin. Thank you for having me today.
So I asked you to come on the show today because I want to talk about discharging student loans in bankruptcy. So can you do that?
Um, yes and no. That's the typical lawyer question or answer, right?
Yes, it is.
Um, there is some good news. Recently, the Department of Justice got together with the Department of Education and put together some updated guidelines. Actually, they're new guidelines because we never really had any guidelines regarding student loan discharges in bankruptcy. So it is great news because as of September of 2022, student loan debt was up to 1.76 trillion, and that includes both private and federal student loans.
Now, will the bankruptcy have any impact, whether it's a government loan, a private loan? Will it all be the same?
Um, the The forgiveness that we're dealing with here is regarding the federal student loans. So those where the Department of Education is involved. There's really no set guidance that I'm aware of at this point, but it seems like the private loans, unfortunately, may be stuck with other criteria, such as the hardship criteria. So I wanted to just run through what we had for the old test when we're looking at these federal student loans. Um, Up until, I won't go back too far, but a little bit of history. Um, Student loans were dischargeable up until pretty much 1998 in a bankruptcy. And then things started to tighten up. As of that point, they were only dischargeable because of undue hardship. And then in 2005, there was a new bankruptcy law passed, which also brought the private student loans in under those undue hardship rules. And the courts in both Massachusetts and New Hampshire used something called the Bruner test, meaning that a debtor, so the person filing bankruptcy owing the loans, had to prove that he or she could not maintain even a minimal standard of living if required to pay these loans. The debtor's situation was unlikely to improve over the years during the loan repayment period, and that the debtor had made a good faith effort to repay the loans in the past. And this was very fuzzy, as you can imagine, because different judges would interpret it in different ways. And then, of course, other courts developed a different test called the totality of circumstances test, which was also very fuzzy. And it resulted in very few student loans being discharged. So now, as of November of last year, we have some new rules that are set forth. And although they're pretty similar to that Bruner test, there are set guidelines. So now we're dealing with what's called an adversary proceeding within the bankruptcy, which is what we did before. That's like a lawsuit within the bankruptcy. So what happens is the debtor sues the creditor to whom he or she owes the student loan within the bankruptcy, and they debate over whether or not that loan is dischargeable. And if they can't agree, then the judge decides. But now there are guidelines and a form that the debtor fills out to determine if the debtor can maintain a minimal standard of living. And the allowable expenses are based on the IRS criteria. So there are set criteria for expenses. They're pretty stingy, but because it is the IRS. However, now we know what the guidelines are. And then Of course, the debtor can also add in things like alimony, child support, daycare, reasonable support expenses, say for an elderly parent or, a disabled child. So there are some additional things that can be added in. And then the court looks at the income and expenses to see if there's money left over to repay the student loans. If you meet that first part of the test, then you go to step 2, which is determining whether this is a long-term situation. So is this just a temporary thing, or will this person eventually be able to pay off the loans? And so we look at whether the debtor is age 65 or older, has a disability or chronic injury, has been unemployed for 5 out of 10 years, whether the debtor failed to get the degree for which they borrowed money, and whether the loan has been in repayment for at least 10 years. So if any of those, and those are not exclusive situations, those are just examples, but if any of those do exist, or, there are similar circumstances, then part 2 of that test is met. And then the third is whether the debtor has made good faith repayment efforts. And that's always been a difficult thing to show, because sometimes student loan lenders would come back and say, oh, well, this debtor's been in deferment or forbearance and has made hardly any payments, and that's not good faith. But now, as long as the debtor has either made payments or maintained regular contact with the lender, applied for deferments or forbearance, applied for an income-based repayment plan, made some sort of good faith effort to deal with this, then part 3 of the test is met. So this is the point at which the parties, have to talk. So the debtor will probably take the position that the loan should be forgiven, and the Department of Justice, representing the Department of Education, probably, may agree or disagree. However, if they disagree, they can go to the judge, and the judge can make a decision, and that would be the bankruptcy judge within the bankruptcy. There's also the possibility of a partial discharge of student loans. So if someone owes, say, $200,000, but it looks like maybe they'll have the ability to repay, I don't know, half of that over the next 10 years, 100,000, then the court may allow a partial discharge. But that's really not clear at this point, and this is so new that I haven't run into anybody personally who has gone through the process. So that's basically it in a nutshell. It's given a lot of hope to a lot of people, because there are people out there really struggling who just cannot pay these loans and really should be able to get rid of them in a bankruptcy.
So I guess I have some follow-up questions. So I'm doing okay, Darlene. I'm paying my loans and I lose my job.
Right.
How do I have to be unemployed before I could say, you know what, I just can't afford these payments anymore? Is it a year? Is it a couple months? Like you said, you mentioned like things being temporary. Is a job loss temporary?
It is if you have the ability to get another job. Obviously, if you lose your job, say because of a work injury, and you can't go back to that type of work, and you may not ever go back to work, that's considered permanent. But if someone is just unemployed temporarily, that's not considered to be a persistent problem. And there is that 5 out of the 10 years rule. So in the last 10 years, if you have been unemployed 5 out of the 10 years, then an ability to repay is assumed.
I'm trying to figure out how I want to ask this next question. I guess I want to call it a lifestyle. So, Darlene, I have a good job. I go out and I buy a really expensive house, really expensive everything. And then I come back and say, I got such a big mortgage payment, big car payment. I can't afford to pay my student loans. Can you do that?
Probably not. Because the court looks at minimal standard of living. So using those IRS guidelines, the court is not going to allow all those expenses. So if you have $1,000 car payment every month and a $4,000 mortgage payment, and you're making, $200,000 a year, the court's not going to have much sympathy for you because you obviously have very inflated expenses. But if your expenses are reasonable, you have maybe a $400 or $500 car payment and, a $2,000 mortgage. And that's the, average according to the IRS guidelines, then your chances of getting the loan forgiven are much higher.
So now, Darlene, if bankruptcy isn't an option, do I have any other options that can help me? Because to your point, there's a lot of people really struggling with student loan debt.
Correct.
Is there anything else they can do?
Yes, what we're running into now with bankruptcies is that bankruptcies are on the rise, but mainly for renters, people who don't own real estate, because people have built up so much equity in their real estate if they bought it, before the boom, that they're unable to file a Chapter 7 without, or maybe even a Chapter 13, which is a debt repayment plan, without, selling off their home or their other real estate. So there are other options out there. And again, the most important thing is to keep in touch with the lender, because there are numerous, it's very confusing. They have acronyms for everything, but there are repayment plans that you can enter into, and there are ways to deal with these loans. We're still hopeful that President Biden's loan forgiveness program will go through, which will give relief to a lot of people. But right now that's stuck in the Supreme Court. So we don't know if that's going to happen or not. But what people need to realize is that particularly for the federal student loans, there is no statute of limitations, which means they basically follow you to the grave if you don't pay them off. You need to deal with them no matter what, because they're not going to go away. And there are more options than there ever have been for repayment programs.
So, Darlene, what's the best way for people to reach out to you? Because obviously it's something that's constantly changing. You really need a bankruptcy person to help you, because what you read online may or may not be true, like you mentioned with, with the president's plan to maybe reduce student debt. We don't know if that's going to go through or not.
Correct.
So you shouldn't rely on it, right?
Correct. We really can't rely on it. And we really need to analyze the whole picture, because you can't, student loans certainly are a big factor for a lot of people, particularly if they, got an undergraduate and a graduate degree. But you can't look at the situation in a vacuum, because unfortunately, as I said, if you have a lot of equity in your home that you've built up, you're not going to be able to do a Chapter 7. You may have to do a Chapter 13, which is a repayment plan, and then try to get your student loans discharged. But it's really, the guidance is there now, and the form is there, and the procedure is much more defined than it used to be. But it doesn't mean necessarily that everybody's going to get their student loans discharged in a bankruptcy.
So what's the best way for people to reach out to you to learn more if they have questions about this?
They can give me a call at 603-898-4383. And I'm licensed in both New Hampshire and Massachusetts, so I can help people in both states. And they can also check out my website, which is Darlene M. Daniele, Daniele, law.com. And I just want to give a short disclaimer that this, this video is not intended as legal advice, and that the legal advice is going to depend upon your particular situation. So you need to consult an attorney who is licensed in your state to address your particular legal situation and the options available to you.
Awesome. Thank you for doing that. And again, thanks for being my friend, and thanks for calling into the show today.
Thank you, Kevin. My pleasure.